Hey there, team. It's Thomas Rowe here, noon sharp. We're at it again. Tell us where you're joining from in the chat. Drop it in there. Share this link right now if you have an athlete or a parent who needs it. More than likely, everybody does. Today's brand protection checklist is in the chat. Grab it before we start. Forward it on as needed. Coach Bronghorst and Aaron Sarles are joining us here today. Let's get into it. We are here weeks 1 through 8. Replay links, brand protection checklist has been downloaded. Week 10 registration link is for August 18th. Capital Wealth Strategies booking link. All righty. Welcome to NIL Office Hours. Where's my mind? Welcome to NIL Office Hours, Week 9. 30 minutes, one topic, real answers every Tuesday at noon. Here's the bridge from last week, team. Week 8, understand the money flowing through the NIL ecosystem. Week 9, protect the name generating that money. Because here's what I see consistently. Athletes spend enormous energy building their NIL brand. Almost none spend any time protecting it. Huge mistake. Coach, one question before we get into the slides. What's the most expensive brand protection mistake you see athletes make, and when do they usually find out about it, and especially when it's too late?
Yeah, I think the biggest mistake that athletes make is they think that NIL is all about their ability to make money. And what they don't understand is what's equally important, if not more, is their understanding on who they're giving permission to, who's going to make money from them.
Right.
And so who's making money off of them? And that's a distinction that a lot of student athletes don't understand who they're giving permission to and how much permission. And they don't realize it until, they think their agreement's over with. And then 90 days later, they're still seeing their name, image, and likeness being used.
Right. Absolutely.
So that's an important distinction.
No question about it. So before we get into it, team, just to give you a little backstory. I'm Thomas Rowe, sports performance coach. I currently work with a lot of high school, college, and pro athletes. And my co-founder and co-host is Aaron Sarles, who takes the mom approach in the business side. And today on our show, we have Coach Bronghorst. Coach, tell them a little bit about you before we get into the next question and what gives us the knowledge and the pedigree to make sure these student athletes and families are set up for success.
Yeah, I appreciate it. I'm a retired athletic and school administrator and head coach of 30 years. Coached at the professional, college, and high school levels. And I retired a little over a year ago. I have 3 certifications in NIL. It's a passion of mine. It's a specialty of mine. It's something that I spend a lot of time on in regards to the education process of NIL and revenue sharing. So kind of turned my coaching hat in a different direction. So no longer coaching on the field. Now I'm coaching off the field in this area. So it's really, really important to pass this information along to families, athletes, athletic directors, and coaches.
No question. Coach, thanks so much for joining us. Aaron, once again, thanks for putting this together. Team, know what you own before you sign. Audit what you've signed before today is over. Let's look at where we're at. Okay, we're going to move on to the next slide here. And Week 9 of 12, 8 complete today, and today we have brand protection. The through line is right there at the bottom. Week 8, understand the money. Week 9, protect the name generated. All right, let's get into it. What's your NIL rights include right now? Coach, walk us through the NIL rights at what they actually cover, because I think athletes assume it's just about social media posts, but it's a lot broader than that.
Yeah, absolutely. When people hear NIL, when athletes hear NIL, they tend to think name plus photograph equals NIL.
Right.
And it's much broader than that. The real issue is whether someone's identity is being commercially exploited. And so an athlete's recognizable identity could potentially involve their name, video likeness, signature, catchphrase, social media identity, and other distinctive characteristics associated with that athlete. And so here's an important distinction that right. They need to know, that you need to know. NIL rights don't suddenly appear when you as an athlete sign an NIL contract. The contract is giving another party permission to use specified rights. And so that's why I always tell athletes, an NIL contract isn't creating your identity rights. It's licensing some portion of those rights to someone else.
That's correct. No question.
And so ownership versus license is very, very important to understand. And it's a huge opportunity to understand what that means when it comes to ownership versus license. And so, like, for example, let's suppose a local car dealership wants an athlete in an advertisement. And so the athlete doesn't necessarily sell their NIL. More commonly, the agreement gives the dealership a license to use specified aspects of the athlete's NIL. So you start asking, what exactly did you license? Is it your photograph? Is it your name, your voice, your social media content? How long? In what geographic territory?
Right.
On which platforms? For which products? As an athlete, can I modify the content? Can the company sub-license it? So can they keep running the advertisement after the contract ends? That is brand protection.
Got it. Love it. Love it. Coach, the bottom half of this slide, what NIL rights don't protect automatically. Walk us through that, because this is where athletes get caught off guard.
Sure. You can have rights involving the commercial use of your likeness without owning the copyright to a photograph containing your likeness. Okay. Those are two different sets of rights. Okay. And that's something that's very important to understand, because generally a photographer owns the copyright,
right,
unless ownership has been transferred or another copyright rule applies. And so the U.S. Copyright Office explicitly distinguishes owning your likeness from owning the photograph itself. Okay. And so that is exactly the kind of distinction families often don't understand when it comes to their, what their rights are when it comes to the different sets.
Awesome. Aaron, let's bring you in here to get into the caddy framework. Accountability over excuses. What's your take on that?
Well, I think this again goes back to, why are we doing this educational series? Is you need to understand what your rights are. What do you have obligations to, but then what he was just speaking to, like, what do you actually need to be responsible for? How do you protect yourself so that you don't get caught in a situation? It's like, oh, I didn't know. So you have a responsibility to make sure you are doing all your due diligence to understand what's actually going on. To your point, what's in that contract? What are you signing away, etc.? That's your responsibility, not like, oh, and a lot of kids get taken advantage of, hence why we're doing this. So you fully understand what you're responsible for.
That's correct. Yep. Own everything about your name and how it's being used starting today. Your NIL can also be used without you ever even knowing. Coach, walk us through the 5. Which one are athletes most blindsided by?
I think the biggest thing that they're blindsided by is the parody and commentary in regards to how that's used. And what I mean by that is that not every unauthorized reference to an athlete is automatically an NIL violation. So news reporting, commentary, criticism, parody, or other expressive uses can implicate First Amendment protections and other defenses. And so commercial exploitation is very different from someone reporting on you, discussing you, criticizing you, or engaging in protective expression. And so a lot of times when it comes to social media and those sorts of things, you see a lot of parody accounts, especially if you're known for something. If you did something in a game and it was like a bad gaffe, then all of a sudden I can tell you some point of that day there's going to be a parody account of you. And so that doesn't mean that they're violating NIL rights. Right. It's just a parody. It's protected expression. And a lot of kids don't understand that.
Yep. So let's get into the AI generated content issue. This is new, and most athletes have no framework for how it works. What do they need to know right now about AI generated content?
Yeah, historically, unauthorized NIL use might mean somebody grabbed your picture. Okay. Now, generative AI can potentially imitate you, your face, voice, mannerisms, appearance, speech patterns. So, brand protection isn't simply, did somebody steal my photograph? It's now become, did somebody create content that makes consumers believe I said, did, or endorsed something that I never participated in?
Right.
Which then adds another layer, becomes your reputation. So the harm isn't necessarily only lost NIL compensation. Now, an athlete could appear associated with gambling, political messaging,
that's right,
controversial products, competing ads, prohibited NIL categories, statements they never made. So the athlete's commercial identity and personal reputation are connected. So could you imagine, and it will not surprise me when this happens, because of how AI has become, you have a really, really good athlete on a rival, and next thing you know, somebody of the rival school has generated an AI of that person, and something that's controversial or something that violates NCAA rules or NIL rules, and next thing you know, this whole hubbub has become, and now it becomes one big nuisance and one big problem for that individual. So don't be surprised when we start seeing that, because of how perverse AI has become.
That is frightening. I mean, what type of protection do you really have? Aaron, one line, what are your thoughts?
I mean, I think you got to just not react. You got to stay in control of yourself and your emotions, document what's going on, and then you'll just have to take appropriate recourse, legal action, most likely, to get it to stop. But first and foremost, do not react. Do not react and document.
Yep. Yeah. Don't start a social media war.
So
nope.
True.
That says something about your character. So you want to go above it, document it, and then you'll have to take the necessary steps to address it. But that's going to speak to your character. Yep. And trust me, the truth always comes out in the long run.
Document first, act deliberately. Here's exactly what to do. We've got 4 steps. Coach, walk us through what an athlete actually does the moment they discover their NIL is being used without their permission. Let's dive into it.
Yeah, just like Aaron just said, first and foremost, document. Don't simply screenshot the picture. Okay? You need to capture who posted it, what was being promoted, where it appeared, when you discovered it, how is it being used. Make sure you save screenshots, URLs, dates and times, emails, direct messages, all of that information. Okay, and the biggest reason why is because digital content disappears. So someone suddenly gets contacted and then delete. Right. That's why it's important that you don't engage publicly. Document it behind the scenes, get all your information, don't engage, because you don't want them deleting it. Okay. And because now what you want to try, because if you do that and they delete it, now you're trying to reconstruct what happened.
Sure.
And then number 2, don't engage publicly. Because the first instinct any athlete's going to have is, I'm going to blast these people on Instagram or on X. Okay. That's a bad first move. Okay. Because you may not know what the contract actually says, whether permission was previously granted, who owns underlying content, whether an agency authorized something, whether the school is involved, what legal remedy is important. So your first move should be evidence preservation, not public confrontation.
Yep.
Number 3, which I think is extremely important, compliance. Notify your compliance office, because if the situation involves recruiting activity, an institutional relationship, or potentially an eligibility compliance concern, loop your compliance office in. They should never find out about the issue from social media.
Right.
And then lastly, seek counsel, seek legal counsel. Because depending on the facts, counsel may determine that a cease and desist or other formal demand is an appropriate first step. And legal counsel can determine which right may actually have been violated. Is it publicity, trademark, copyright, contract, false endorsement, etc.? Let the professionals do their job.
Yep. Talk to me about a cease and desist. Most athletes have never heard of this. How does it work, and roughly what does it cost?
That, from the cost standpoint, I don't have that number in front of me. I can find that out for the audience. But basically, a cease and desist order is that legal counsel will seek an order and they submit it to the appropriate party that all activity that they're engaging in must stop immediately under a specified number of time. It could be indeterminate, immediately, whatever the order says, but they no longer can participate in the activity in question. If they violate that, they're in violation of the law, and then they're subject to legal issues.
Good God. How sticky can this get? Team, you got to really pay attention, be ahead of it. That's why we always talk about being proactive, not reactive. Aaron, let's have you jump in regarding the caddy framework surrounding this issue.
I would link this to integrity over image. And this just means like how you handle this is a reflection of you. So if you do what we outlined, if you document what you did, you don't react publicly, and you take the necessary recourse, that speaks volumes on you. If you start getting wild and crazy on social media, whether it's commenting on the post, making a crazy post about them, that says everything about you. So again, your actions are a reflection of you. Their actions are a reflection of them. And you have legal recourse to handle the situation properly. So do not react and take it into your own hands.
Awesome. What you own and what the platform owns, the difference matters. Coach, trademarking your name, when does it actually make sense for an athlete to do that? And what does it involve practically?
Yeah. Well, so first of all, let's define what a trademark is. Okay. It's simply not, I legally own my name. Okay. A trademark identifies a source of goods or services. And so that's a critical distinction. Athletes with increasingly commercial personal brands may consider federal registration with their name, nickname, logo, slogan, or other branding that is actually functioning as a mark in commerce. So the U.S. Patent and Trade Office now has specific name, image, and likeness educational guidance, which is useful confirmation of how important this has become. And so the current USPTO has base trademark application is roughly $350 per class, although other fees may apply. So I highly recommend athletes and families get on that website. It's uspto.gov. And so when trademark protection and when it can become important is I think a great example would be, imagine an athlete becomes nationally known and begins selling merchandise, holds his own camps, training services, media products, or other branded goods and services. Now their name isn't merely identifying as a person, it's functioning commercially as a brand identifier. And so that is where trademark strategy becomes increasingly relevant.
Gotcha. So let's get into social media platforms. Athletes post content every day without thinking about what they're actually agreeing to. What's the one thing every athlete needs to understand about posting?
Yeah, basically, when you post something on social media, it doesn't necessarily mean the platform now owns your copyright. Okay. It typically, the user retains ownership, but grants that platform certain license rights under its terms of service. And those are two different things. Ownership does not equal license. And so when you post content, don't assume you gave away ownership. but don't assume the platform has zero rights either. You agreed to terms of service, and those terms matter.
Sure.
And it's like what I was talking about with the photographer distinction. If someone else took your photo, the athlete may never have owned that photograph's copyright in the first place. And so the copyright office says the photographer generally owns the copyright for the moment that the photographer created that photograph. And so that makes the whole area a right stack. And so you have athletes' likeness rights, you have photographer copyright, and you have brand contractual usage rights. And those are 4 potentially different interests involving one Instagram post or photo. Okay, and so that's significant to have to understand in this whole social media platform.
So true. Aaron, how about you jump in here? Character over cloud or bringing in the caddy framework?
I would say you want to build a brand worth protecting and building. So if you're going to, if you just everything he just spoke to, you've got to think about, is the quality of what I'm building worth protecting? And that would be my question. So a good brand would be worth protecting.
Mm-hmm. Absolutely.
Well, we're going to get into the 6 things that we need to know and understand right now. Coach, which of these 6 do athletes skip most consistently, and what does that generally cost them?
I think, the right to allow others to embed their posts and the ability to use their contact and their advertising. I think those are 2 that matter the most for them, because it's generally, when it comes to social media posting, they just go out there and they post, and they don't understand the rules governing it, and who can post now, who can sub post it, and the things behind that. It's so important to understand what you're doing when it comes to social media.
Perfect. Aaron, the quote at the bottom of the slide, yours. What exactly does that mean?
I think, I'll just keep reinforcing what I say. Integrity over image means your brand is worth protecting. And so it starts with you. Who are you? Who do you want to be? And what you're putting out reflect a high quality human being. And the better your quality is, it's going to be worth protecting. So if you're sloppy and half-assed and a multitude of other things, you probably don't need to worry about too much of that stuff. So think about who you are, who you want to be, and are you putting that out into the world? Because that is what we're talking about, that's what's worth protecting.
100%. Let's start protecting it today, team. The checklist is in the chat right now. Download it. Set up the Google alert tonight. 60 seconds. It's free. Let's get to some questions. Let's go right into the chat here. We've got a few extra minutes, Coach. I found a brand using a photo of me from 2 years ago in their current advertising. I never agreed to this. What do I do now? How should I reach out to them?
Yeah. So I think, when you discover that, unauthorized use, document it. Capture screenshots, dates, URLs, the account, the advertisements, context, before contacting anyone. Review any, if you had a previous agreement, review that agreement. If you need to involve legal counsel, do that. But also, if you involve your compliance office as well.
No question. Okay, Coach, someone has a fan account using my name and highlights, and they've been selling merchandise, which I'm not getting any part, nor have I agreed to this. Is this legal, and what can I actually do about it? I assume it gets into that cease and desist.
Yeah, I mean, that's where if there is no contractual agreement there, and they made a parody account and they're posting highlights and they're making money off of you without authorization. Yeah, that's you need to contact legal counsel to get cease and desist immediately.
Got it.
Because that's just something that cannot happen. That's a brand protection for you.
100%. Coach, do I need to trademark my name before I start pursuing NIL deals?
No, I mean, trademark registration should be part of a business strategy. not simply something every athlete does because they're participating in NIL. So it becomes more relevant when you as an athlete and your name or branding is functioning commercially to identify goods and services. Just because you're in an NIL deal doesn't necessarily mean you need to trademark it.
Sure.
When you become commercially relevant, that's where you need to think about that.
This is awesome. 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 Team, know your rights, document everything, set up a Google alert tonight and know who to call and why to call. Your brand is worth protecting. Let's start today. And brand protection checklist, that's in the chat right now. Download it and let's get ready for next week where we have NIL red flags. How to spot a bad deal before you sign it. Register in the chat right now and we will see you next Tuesday at noon. Coach, where can people get a hold of you other than the QR code that we have right here?
Yeah, you can find me on LinkedIn under my name, John Bronkhorst. You can find me on Twitter X at Coach Bronk. That's CoachBronk. Reach out to me, ask me questions. If you need any help, let me know.
Awesome. Denise, you're absolutely amazing. We've got Denise chiming in from Kenya. We have a big reach here, Coach. And Aaron, thank you so much. We can't wait to NIL to make its way to Kenya and so forth. Aaron, thank you so much for being the magician to make the magic happen. Everything we do here is because of you, Aaron. Thank you so much. Coach, thank you so much for joining us. And team, we will see you next Tuesday. Have a fantastic rest of your day.
Thanks, Aaron and Thomas.
Of course.